Good morning, good afternoon, good evening, depend on where you are. Giving the growing attention to the intersection of intellectual property and genetic resources, traditional knowledge, and traditional cultural expressions, AIPPI and AZIP are pleased to show a new series of webinars to be held in 2023, exploring these important and developing topics. This series is part of the ongoing AIPPI and AZIP collaboration, which was signed at the AIPPI Congress in San Francisco last year. So welcome to our webinar series. On the first round, we have been discussing the European legal framework for IP protection of genetic resources, which it was divided into two parts. The first one took place on April 25th and discussed the legal framework for IP protection of genetic resource and the interface between IP and access and benefit sharing requirements from the European, Latin America, and Japanese law perspectives. In the following 2 months, we will have a second round of discussions on intersection of IP and cultural heritage and traditional cultural expressions. The first part will be on June 20th and the second one on July 18th. So today we will continue discussing the European legal framework, and our presentations will cover several aspects related to plant varieties and animal breeds, such as legal framework, administrative bodies involved, requirements and procedures for obtaining a PVP certificate, validity term, statistic and main examples, and connection with cultural heritage and other IP issues. I'd like to call your attention that if you would like to make a question or a comment, there will be a Q&A session at the end of all presentations. The questions addressed to the speakers should be submitted via the Q&A function. You can click on the Q&A, the icon Q&A that you can see on your right in the red line, the red circle. For technical problems, please send a message via the chat function to AIPPI events. The recording and the slides from today will be available upon request, and you can send an email to events@aippi.org. Translations will be available from English to Spanish and from Spanish to English. There is a brief survey after the webinar. I thank you in advance for your feedback. So having said all that, let's begin with the presentations. But firstly, I will introduce myself. My name is Ana Cláudia Carneiro. I am partner at Danimas Siemens, IP agent and chemical engineer in Brazil. Our first speaker will be Silvia Todorova. She is Chief Assistant Professor Doctor at the University of National and World Economy, Sofia, Bulgaria. Partner of Todorov firm and IP attorney with 13 years of experience in the field of patents, trademarks, industrial designs, and plant varieties. IP, the advisor of the Bulgarian Agricultural Academy concerning the protection and enforcement of genetic resources. Silvia, welcome, and the audience is yours.
Thank you, Ana Claudia, for introducing me and for giving me the floor. I'm very glad to participate in this webinar. Hello, everyone. Good morning, good evening, good afternoon for everyone listening to this very, very interesting webinar. That will cover the protection of plant varieties and animal breeds in Bulgaria, in Croatia, and in the European Union, as well as I will identify very good practices and knowledge about transfer of technology in Bulgaria, in European Union, and all over the world. So the protection of plant varieties in Bulgaria is governed by the Act of Protection of New Plant Varieties and Animal Breeds that was adopted in 1999 and then amended several times during the years. The Act applies to plant varieties of any botanical genus and any varieties, including clones, lines, hybrids, also rootstocks, created or even discovered and developed, irrespectively of the method of their production. So this could be artificial or natural method of production. When talking about European Union, the main legislation there is the Council Regulation number 2100 from 1994. That is governed for the community plant varieties rights. We must mention here that as part of the European Union, all the countries has adopted this regulation, the European Plant Variety Regulation. So the legislation that we're going to cover for Bulgaria and we're going to discuss is really harmonized with the European one. First of all, I would like to address the administrative bodies that are involved in the procedure for granting legal protection of plant varieties in Bulgaria. So these are the Executive Agency for Variety Testing, Approbation, and Seeds Experts. This is also the Patent Office of Republic of Bulgaria. In the first agency, the executive agency, we make the technical expertise, which is to verify that one plant is distinct from any other, that it is also uniform in its characteristics, and it is also stable in a long run. Also, the patent office is involved in the proceedings, but it only makes the formal examination. I will talk about a little bit later about this examination, and it issues the certificate. In the European Union, we're talking about granting IP protection for plant varieties. There is one administrative body involved, which is the Community Plant Variety Office. And of course, the technical examination is carried out by one of the entrusted examination offices of the CPVO network. We're going to talk about this a little bit later. So the legal protection of varieties is usually granted if the varieties has these four characteristics. It should be distinct or discernible. It depends on the legislation. In Bulgarian legislation, it said that it is distinct. In European one, it is discernible. But anyway, these are equal terms. Also, the plant variety should be uniform or homogeneous. It should be stable and new. What does it mean? So the distinct means that the variety shall be considered distinct if it is clearly distinguishable from any other variety which is known by the date of the application in the patent office. Also, the homogeneity, it means that the variety, regardless of the presence of small deviations, all the plants are identical in their essential qualities, including regarding particularities of their vegetable reproduction. Here we have to mention that usually the technical expertise in Bulgaria takes between 2 and 4 years. In Europe, it could take between 1 and 6 years. For certain fruit trees varieties, it could be even for 6 years. That's why it's very important before that to have all these criteria fulfilled. So stability means that the variety is stable when it remains unchanged in its essential characteristics after repeat reproduction. One more time, we need this 2, 3, 4, sometimes 6 years to see that this variety is really stable. Some words about the novelty. So the variety is new when on the filing date, it or part of its harvest is not offered for sale or sold or subject of another kind of trade with the consent of the breeder as follows. For the territory of the country, for example, for the territory of Bulgaria, for no more than 1 year, or for the territory of any other country for no more than 6 years for trees and wines, and no more than 4 years for any other plant species. Let's talk about a little bit the methods of procedure in order to grant protection of plant variety in Bulgaria. As I mentioned, we have two bodies involved in this procedure. The patent office, where the application is initially filed. So the applicants file the application in the patent office, and from the date of application, we have the priority date retained, no matter how long the examination will take place. Then the patent office first makes, of course, the formal examination, which will take about a month. Sometimes it could be up to 2 months. And then the patent office forwards the application to the executive agency for the technical expertise. Also, the patent office will make the first publication of the plant variety in the official bulletins, so third parties could see that there is a plant varieties which is already filed with the National Patent Office. Of course, a notice of payment of the expert fee is sent to the applicant. And if the fee is paid on time, the executive agency will start the technical examination or the examination in substance. We have two ways to end this kind of procedure with issuance of a technical report, which says that all the criteria is covered and the plant variety could be registered, or we have refusal for protection. So this is the second step. It's very important to mention that only the agency could make this expertise. The patent office is only involved with the formal examination. Then the agency is sending the documents and their final decision to the patent office, and the patent office is supposed to issue the official document, which is the certificate for IP object. The patent office makes the second publication in the official bulletin. So we have two publications in the official bulletin, one with the application and the second one with the registration, if we have registration. They make the entry in the register, second publication, notification of the holder, and dispatch of the certificate. About the certificate, the land protection of a variety is provided by certificate, as we mentioned, and this certificate proves the presence of registered varieties, the priority, of course, the right of authorship and the exclusive right of its owner, because sometimes, just like in the patents for inventions, we have different author and different owner of the executive and exclusive rights of intellectual property. Also, the certificate shall be enforced from the date of registration, from the date of issuance, not like with the other objects of IP from the date of application. Here we have a registration date, which is very important because all the legal terms start from this date. The legal term for protection is 30 years for trees and wines and 25 years for all other varieties. It's very interesting to share some registered plant varieties in Bulgaria. So we have more than 1,500 applications received in the Bulgarian Patent Office. From these applications, about 75, even more than 75 applications have been registered during the years. Of course, some of the applications, some of the certificates already lapsed due to the term of protection, which is expired. And nowadays we have 22 registrations in force for mainly for field crops, for example, wheat, corn, barley, etc. Also fruits, a lot of different fruits registered as plant varieties. Also, we have vegetables like zucchini, tomato. I have very interesting example for tomato, which will be shown in the next slide. Cucumbers, and etc. We have also the flowers, which are very important nowadays. For Bulgaria, it's also important the oilseed crops and the flowers that are related to the Bulgarian roses, which are very famous and very good transferred as technology to other countries, and the lavender as well, we should mention here. Also plant varieties registered for wines and any other species. I will not mention all of them. One very interesting example is about the pink tomato that was first grown in Bulgaria over 125 years ago. So the tomato is very interesting. That is a large, with each fruit growing and reaching up to 300, even sometimes 500 grams, which is half a kilo tomato. The skin is very thin and smooth, and the fruits are really very tasty and with delicious flavor. So this is one of the examples that are very famous for Bulgaria and are very famous not only here, but all over the world for the last 10 years since the certificate was issued for this kind of plant varieties. Something about the databases we should mention. I think it's very important and interesting, not only for the business, but for IT practitioners. Two of the databases which are very useful for community plant varieties registrations. First one is the CPVO Variety Finder. This database is maintained by the CPVO, and it contains information on registered of more than 70 countries with general search tool. It also includes similarity search tool to test the suitability of denomination, for example. This kind of database contains plant breeders' right data, so community plant variety rights data published in the official bulletin, the official gazette of the CPVO, also national data of protected varieties, as well as national insights data and common catalog data, some commercial registers. It's very interesting that you can also find EU registered trademarks for class 31 that concern the plant varieties and seeds. And also you can find in this database interesting examples for plant patents. And of course, other type of data. The second database is the one that is that concerns the online application for EU plant varieties, which is suitable for online filings of community plant varieties protection. Something interesting that should be shared is about the EU funding, which is now very useful. So all the small and medium enterprises could apply for a voucher. It's called voucher number 4, which is for community plant varieties, and can gain €225 for online applications, which is 50% of the official fees. This voucher is granted from the SME Fund in European Commission initiative implemented by the European Union Intellectual Property Office, and runs from the beginning of the year, from January 23rd to almost the end of the year, to December 8th. So the fund provides vouchers for intellectual property protection only to small and medium-sized enterprises within the EU. We should mention that for the first time, the SME Fund also helps small and medium enterprises to apply for protection with community plant varieties office. So far, we have these vouchers for trademarks, for industrial designs, which is 75% of the fee reimbursement. We have reimbursement of 75% of the fee. Also for patents, for inventions, we have voucher for 50%. And now for the first time, the fund helps small and medium enterprises to apply for protection with plant varieties office. This is particularly relevant to the European breeding sector, because as shown by the recent EU IPO and CPVO study on the impact of the CPVR system on the EU economy and environment, most of the companies protecting their innovations with CPVRs are these small and medium enterprises. So the funds are limited and available on first come, first serve basis. And we can have this in mind when applying for community plant variety protection in EU. Some statistics that I consider very interesting. For example, the number of community plant varieties applications received so far. The total number of applications received in the community plant variety office from 1995 is already about 80,000. We have like half of them, like 50%, for ornamental crop sector, then about 20,000 about agricultural crop sector, some applications more than 10,000 about vegetable crop sector, and of course the fruit crop sector. You can also see the evaluation of the number of applications received in the last 5 years. As we can see, there are like about more than 3,000 applications received every year in the office. What about the number of community plant varieties rights granted? We can see that about 80% of the applications after examination are granted. So the statistics shows that about 62,000 plant varieties are granted from the community plant variety office so far, and we can see that the number of grants still in force is more than 30,000, which, comparing to other objects, is not a very big amount. However, considering the plant varieties expertise, we should say that it's really a great number for registered object as intellectual property. There is also here under evaluation of the number of rising force since 2018 for the last 5 years. As we can see, we have growth here. So the sector is growing. The statistics are certain that the sector is growing. Just a little bit more statistics about the network of examination offices in the EU until the end of 2022. So we can see on the map the places where the DUS examination, this is the technical examination, is carried out or was carried out in EU. The number of reports and requests received is more than 20,000. It's almost 13,000. And the numbers of sale of this report since 1998 so far is are more than 8,000. We should also mention the top 5 countries for sale of these technical reports, which are Colombia, Brazil, Ecuador, Canada, and Israel. You can see here on the chart. And also the evaluation of number of sales of these reports to national authorities since 1918. Important thing about the transfer of technology from Bulgaria to other countries should be mentioned that Bulgaria has very favorable natural conditions that substantially contribute to the development of new plant varieties every year. So in this sense, Bulgaria is the major stakeholder in the technology transfer with countries from all over the world. So we have transfer of technology from Bulgaria to other countries. For example, for Moldova, 4 types of soybeans has been transferred with license agreements. My colleague Ivana Konda will talk about deeply about transfers and license agreements. Also from Hungary, from Bulgaria to Hungary and to Turkey. The transfer of technology is about wheat plant as a plant variety. Also for Congo, it's very interesting that nowadays there are a lot of requests from countries like Cuba and like Congo and other countries, for example, in Caribbean or in Africa, that request transfer of technology from Bulgaria to these kind of countries. Also, Kazakhstan, there is a signed license agreement for sunflower, and of course, more others. Concerning the animal breeds, we can also mention that the body involved in the procedure is, of course, not the same like for the plant varieties. The body involved is the executive agency for selection and reproduction and animal breeding, which is part of the Ministry of Agriculture and Food in Bulgaria, and also the Patent Office of Republic of Bulgaria. The proceeding is very similar to that one of the plant varieties. However, the special requirements are different. The main special requirements are the following. You can see the breeding purposes, also the brief characteristics of the original breeds, description of the method of creating the breed, productive qualities and morphological particularities of the breed, adaptive ability and resistance to diseases, tribal and genealogical structure, and also the region or area of propagation. So these are the special requirements for animal breeds in order to grant protection in Bulgaria. The certificate for animal breed is valid for 30 years from the date of issuance. We can mention that, of course, usually it takes about 7, even 10 years in order for one animal breed to be selected. And then the proceeding for registration is about sometimes 5, 6 years. So after that, we have protection for 30 years. The animal breeds in Bulgaria, as a statistic, we have 75 applications and registrations granted. For example, the last one was for Bulgarian sport horse, which was granted last year. Also, the Bulgarian teen crowned sheep, shorthorn beef, the silkworms, which are nowadays very famous, not only in Bulgaria, but also in the European Union. A lot of animal breeds for dogs and fish, and of course, others. One interesting example about Bulgarian hoodless short-beaked pigeon, which is also called wild rock pigeon. Its main breeding sector in the north and eastern Bulgaria. It's a very good adaptive animal breed that it's also exported in Europe. We also, as I mentioned, have 9 registrations for silkworms, which are really very popular now, as we mentioned, not only in Bulgaria, but in European Union. Usually these kind of animal breeds are selected in the Bulgarian Agricultural Academy. And we have to mention that more than 90% of all plant varieties and animal breeds are selected in the Bulgarian Agricultural Academy. Only about 10% of the animal breeds and plant varieties are selected by the private sector in Bulgaria. Also, the transfer of technology and license agreements are signed with the Agricultural Academy, which is actually part of the Ministry of Agriculture and Forest. Talking about the silkworms, we should mention, of course, the Horizon Project Arachne, which is about the rebirth of the silk industry. This project advocates the role of the silk art and cultural heritage in national and European scale. Bulgaria is a partner with this project with the Scientific Center on Sericultural, which is located in Bulgaria, and is part, of course, of the Bulgarian Agricultural Academy. So 11 partners and 3 associated partners from 7 European and non-European countries are part of this project. My colleague, Professor Silvia Capellosa from Italy, will talk about this project deeply in one of our next webinars, which will take place on the 18th of July, which will be about the IP and cultural heritage and traditional cultural expressions. So she will go deeply in this project and the role of this silk art. Thank you very much for your attention. I now can give the floor to my colleague, Professor Ivana Kunda from Croatia.
Yes, so I'd like to introduce our second speaker, Ivana Kunda, and she is professor at Faculty of Law of the University of Rijeka and Vice Dean for Research in Croatia.
Thank you very much. I hope we can hear each other well. And I would like to greet you all from Rijeka in Croatia. It's my pleasure to be here today and to speak at this very interesting topics. And I will try to also add to understanding of this topic by sharing with you a couple of notions related to situation of protection of plant varieties in Croatia. I would like to say that I have tried to somehow include in this presentation the perspective on the new plant varieties as well as on the old ones, because I think this is quite interesting. What I can also share with you for the beginning is the map of Croatia. That's how it looks like in the south of Europe, southeast Europe, and the green are the forests. So this is not agricultural purposes that important, except when it comes to trees. But then we can see the pale color beige is pasture and valley farming. And then we come to this coastal area on the Adriatic Sea, which has permanent crops such as olives, grapes, and citruses. Further south are citruses as well. The pink areas, it was difficult to show it in the map, so they mixed all kinds of things in the pink area, such as grains, horticultural vineyards, and livestock, and whatever. And then we see the field crops, this pale yellow-green color. Also, you can see where grapes and sugar beets are excessively grown in certain areas. So this perhaps can give you a bit of an idea what Croatia looks like in the context of growing the plants and where the interests come with relation to specific varieties. Some statistical data can tell us that in 2021, the area under agricultural use was around 1.5 million hectares, and only a small part of it actually belongs to ecological type of production, which we can see in the middle. What is interesting to see is that the share of agricultural trade in total trade with EU member states for Croatia is 15.36% for export, and 13.46% for import. So they're pretty much there. However, perhaps we could be more efficient in exporting because we do have quite a good I'd say climate and soil to expand the growth, but hopefully that will happen also in the future. Turning to the legal points, just let me remind you that Croatia became a member in 2001 of the UPOV Convention, that Croatia became a member of the European Union and started applying plant variety regulation, which was mentioned by Sylvia as well, with the beginning of July 2013. So we will be celebrating 10 years in EU in a couple of days. Then we also have the national laws, which is then the similar situation already explained in EU member states, because those systems run in parallel. The community plant variety is the IP right, which is territorially spread and encompasses entire European Union. So once a community plant variety has been registered, it is valid in every country of the European Union. Unlike the plant varieties which are registered under national law, those are only limited to the borders of a country for which they have been registered. So I can say that the Plant Varieties Act, which is currently in force, has been enacted in 1997 and amended a couple of times ever since to accommodate some of the international or European changes. But just as Sylvia pointed out, the national law is very much harmonized with both international and European Union laws, so that there should be no surprises there. And I would not repeat the same conditions for registration certification, because that can more or less be taken as the same for Croatia, is applicable to Croatia as well. And this is also the situation when it comes to community plant variety, which was already mentioned. However, in Croatia, we have two other institutions which take care of the plant variety registration. This is the Ministry of Agriculture and Croatian Agency for Agriculture and Food. The Intellectual Property Office is not involved in this. Traditionally, this has been the job of the agricultural specialized institution, so this has been inherited from before. Never was Intellectual Property Office involved in this agricultural protection in the past, so I suppose this was the result of this kind of allocation of competencies in Croatia, unlike in Bulgaria. The Croatian Agency for Agriculture and Food has many other competencies besides the one which pertains to, for example, examination of the requirements, registration, and keeping the register of the plant varieties for Croatia, because it also deals with quality of food and quality of production, agricultural production, and so on and so forth. I would like to share with you also some of the slides which are somehow continuing what we already heard, which is the distribution of the species in the as registered in European Union as community plant variety. And we can see that huge numbers relate to ornamental species and also agricultural species. And here are some of the leading ones, so you can perhaps get a bit of an idea what is interesting and what is happening in Europe now when it comes to registration of types of species. This is similar information, which also gives you an idea of how many of those we saw in 2022, which is the last year for which we have the data, just the last year. And we see that ornamental species and agricultural species are somewhere there, leading. Perhaps agricultural species have been taking the lead in the last. When it comes to community plant varieties, this always gives perhaps the best feeling of the changes and statistics. So we see the rights that have been granted for different categories of species, nicely visible here in this slide, and changes how it was in 21 and how it's now in 2022. Very similar situation as we can see. Perhaps we can talk about it later on somebody is interesting. The reason why I'm sharing with you this interesting picture from medieval times is that I have actually been reminded of, when thinking about these numbers, of this tulip fever, or the tulip boom, or tulip bubble burst, whatever we want to call it, which happened in the Netherlands at some point in the past, because people suddenly started to realize that there is a huge demand for flowers. And the flower market indeed is quite vivid, quite good in EU, but also across the Atlantic in US. It is one of the very, very lucrative markets for those who would like to grow plants. So it's worth of remembering this fact. And we in Europe import a lot of plants, but however, I think that 40% of the plants come from the Netherlands. However, the rest, or even the market share, is still there for some outside EU to perhaps compete. Moving to the national law now, I would like to give you a brief idea of how the Croatian law treats plant varieties. So the scope of the Plant Varieties Protection Act is, in terms of what it covers, until 2011, it was very limited, only to those 13 categories of plants. And then later on, you will see that this has an effect on the types of protected varieties, actually. You will see that they are also kind of limited mostly to this list as well. Still, even if we were more than a decade away from liberating the market, let's say, because from 2011 onwards, all kinds of plant varieties, any botanical species, including hybrids between genus and species, could be protected. There is no limitation anymore. And this was part of one of those amendments that I mentioned before, which was intended to harmonize Croatian law with the law of the European Union before the accession. When it comes to personal scope, Croatian nationals residing in Croatia are the category which is mentioned as those who are entitled to ask for protection. However, also foreigners who would enjoy the national treatment under the international treaty in force with the country. So that's basically the rule. If we are looking at the transfer and license, because Sylvia kindly mentioned that, I'll give a couple of notes about that. In Croatian law, it is mandatory that this is in writing. It's registered in the register kept by the agency. Otherwise, neither transfer nor license will have erga omnes effects, so effect towards third parties. So if it's not registered, a third party will legally acquire the same right, irrespective of the fact that earlier on this right was subject of a transfer or license contract. So that one has to bear in mind that it's very important to get to the register once you conclude the transfer or license agreement. When it comes to licensing of plant variety right under Croatian law, then if parties do not agree on anything, it will be considered that the license is non-exclusive, because that's the idea, that the scope of use should be as wide as possible. And if parties want to make it exclusive, they have to particularly negotiate that. Also, licensee has to maintain the quality of the goods they produce, and use the trademark and signs, other signs potentially, which are agreed under the license. This is one of the explicit legislative obligations of the licensee, and it's very important to know that even if nothing is mentioned in the contract, this is the obligation. Payment of royalty is due no longer than each year. So you don't have to pay it every month or so on, but at least each year a royalty has to be paid. It cannot be paid every 5 years or something like that. So it's considered also a mandatory provision. Also, the licensor has a right to receive licensee's report on the exploitation of the right, and that's also every year because it's related to the payment of royalties. One of the things that can happen is that, of course, the royalty becomes disproportionate because the plant is somehow successful on the market. In that case, the adjustment may be claimed from the licensor and then a licensee, and then if the licensee does not agree to the adjustment, then the court would be there to decide. Sub-license is permitted without consent of the licensor unless they have decided otherwise in the contract and have limited this option. And in case of death of the licensor, the license passes on his or her successor. Also can be agreed otherwise. Just like in a case of bankruptcy, the licensee has the right to avoid the contract and just get out of this awkward situation that might be, he or she may find himself in. And now if we are going further to plant varieties in Croatia, I would like to mention that this is the list of those which are currently in force. There are not that many as in Bulgaria, but yeah, we're not the countries of the similar size either, but anyway, I think this is rather the result of the previous limitation of types of plants which you could actually protect. So we see that we have one such in oil and fiber plants. We have 27 of cereals when it comes to barley, one spelt wheat, 32 wheats, and then we have this special crossing, 2 of them. And the forest plants, we have one white willow, then we have this combination hybrid between Chinese and willow and white willow, 2 of them, and the Chinese willow, 1 of them. So if we have them all added up, it's 67 altogether. I'd say not a lot, not little, but certainly could be more that we could see. I also wanted to use this opportunity to share with you some notions of how Croatia deals with some of the old varieties. And for this purpose, I thought it would be nice to see how the key biodiversity areas are mentioned, and then it is not directly connected to our topic, but it does tell us a little bit about who is aware of the need to protect some of the resources, natural resources, and also genetic resources to some extent. This is rather an awareness slide than an information about animals. We see that in Croatia we have quite so many such areas of protection, especially on the coast. Almost each island is on its own an area. And that is having to do with the fact that Croatia is the party to Treaty on the Plant Genetic Resources for Food and Agriculture, which is in effect in Croatia since 2009. And we are also members of the European Cooperative Program for Plant Genetic Resources, ever since the phase 5, and of course now in the phase 10, which ends this year. And these are, let's say, the purpose or aims of this program, which somehow also correspond to protection, which we are talking about today. And as a result, Croatia has developed the national program for conservation and sustainable use of plant genetic resources for food and agriculture for the period of 2021 to 2027. And this is the third programming period in Croatia, continuously running since 2013. And the aim is to promote conservation and sustainable use of plant genetic resources. The program is financed from the state budget partially, and partially from the EU funding submeasure in rural development program. So important thing here is that in the first programming periods, mainly institutions were involved, scientific institutions and companies. Now we also have much larger involvement of farmers associations and in order to get all stakeholders in this to promote ex situ and in situ conservation of plant varieties. And one of the results of this endeavors is the Croatian Plant Genetic Resources Database, which is open access. I'll just quickly try to go through this information. We can see the number of entries into this database and how different categories are distributed. In this case, and this is the website if anybody wants to go and check, because it's also in English, available in English. So one of the things is this potato, and in the context of industrial crops, which was actually part of the efforts which began in 2007 in the Ministry of Agriculture and some of the institutions outside Zagreb. The industrial plants is the aim of collecting, maintaining, characterizing, evaluating, and regenerating indigenous domestic populations, as well as newly created varieties of industrial plants, in case they are not commercialized. Those are the two basic focuses, and we see that this is related to industrial plants. We also have some other such examples of pumpkins and poppy seeds. In the context of vegetables, this working group on vegetables has been established in 2005 with the same idea when it comes to vegetables, and they collected these, including also garlic. Garlic is something that Croatians very much love and use, and it's they're very proud of their national type of garlic. So it's also part of this endeavors. You can see that areas in which these activities take place are different. Some are close to the sea, some are in the continental part, and so on. And this is the main characteristic of the system. It's basically its distribution in the country, which is decentralized. As many as probably 10 institutions are involved in this process, and they each of them keep specific amounts of those seeds, and they continue growing them and maintaining them. So this is something that has been actually divided according to the climate, but also according to how interested people were. So they found some enthusiasts and people who would love to do these things, and that's where it's located. And it's not necessary that it's all in one place. I think this model of allocating the work and databases and the basics of these genetic resources is quite working well for Croatia. Let me just show you how it was for the grape wine and for the grapes. You can see the grapes. We can see that there is 242 entries, which we can see here for Croatia, different types that you can access. And in the end, the biggest category is medicinal and aromatic plants. Sage, for example, in Dalmatia, and many others. So the accessions are usually, in this case, held at ex situ, at the maintenance facilities, either in Zagreb or close to the Adriatic Sea in Split. And they're carried out by those who are specialists in this protection. And I think that I have exhausted my time actually, and I don't want to take anybody else's opportunity to comment and ask questions. So thank you very much for your attention.
Thank you so much, Ivana. And now we have our Q&A session. And I have a couple of questions here to Sylvia. And Sylvia, is it possible for the applicant of a plant variety to first make the technical examination and then file the application for an IP protection with the patent office?
Thank you, Ana Claudia, for the question. Yes, for Bulgaria, it is possible first to file the application with the executive agency. So if you have the positive report from the executive agency, the positive technical report, you can then file the application with the patent office in order the patent office to issue the certificate. It will take the same time as the technical examination will again take between 2 and 4 years. And then we just file the application with the patent office, and let's say for 2 or 3 months, we will have the certificate issued. However, in this case, the applicant will lose the filing date. So it's better if first the application is filed in the patent office, and then they just transfer the application to the executive agency. But yes, you can file the application with the agency first, and then with the patent office.
Okay. And is there a time limit after filing a national application for a plant variety for filing a community plant variety application?
Yes, there is a time limit. The time limit is 12 months. So 1 year after the filing of the national application, the community application should be filed in order the plant variety to be considered new. So it's 12 months.
Okay. Thank you, Sylvia. And Ivana, would you please comment about the statistical data related to European PV rights, and particular to the growth in ornamental varieties, reasons for location of this growth? So general comments.
Sure. As I mentioned, I think there is a kind of tendency of a fast growing sector in flowers industry. And that is actually having a huge effect on the production of flowers and new plant varieties as well. I found some data when it comes to the period of 2015-2020, which says, for example, in United States, the average industry growth was 6.3%, while the flower shop industry grew 8.5%. So that's really a huge difference. It's something that indicates that people are more and more likely to buy flowers, to give flowers, that this culture of giving flowers and honoring someone with flowers is very developed. And for example, 70% of all Mother's Day gifts in 2018 in United States was flowers. So that's a lot. And no wonder that we see this reflects on the growth of the numbers of ornamental varieties. I don't know what your personal experience with flowers are, but perhaps if we just think about it, we see that most events, celebrations, and so on are, even those private ones, involve some flowers, cut flowers, or at least indoor flowers. If you don't buy those for the vase, you might want to buy those which will grow in a little pot. And yes, many nations have found their little niche there, either for example, the roses, such as Ecuador, I think, and Kenya, or some others, Thailand for exotic orchids, and so on. We should maybe ask ourselves what kind of psychological effect the flowers have on us. But apparently, they do have a lot. At least the numbers tell us that.
Yes, I particularly love flowers.
Mhm.
The beginning of the pandemic, I can say that since then, every week I buy flowers. Yeah, so
Okay.
colored flowers, red, the orange, yellows, and so my room is full of flowers. Yes, and
Well,
I
some
like to
studies say,
go.
yeah.
Yes, I like to go to the places that sells the flowers and
Mhm.
plants. Yes,
Yes, some
the,
of the
the day
studies
becomes
tell us
better.
that actually the flowers can trigger some of our hormones,
Yes,
like
I
maybe
fully agree.
dopamine or some other, and that explains it actually. But also it's part of the culture, so it's not. It depends on the areas in the world in which it's more or less present. But I suppose in the countries in which people have higher living standard, they more often tend to buy flowers. I suppose they can afford to buy flowers more. So if we look at the global map and see the trade in flowers, we can probably have these areas more colored than the others. Let's put it that way. In
Yes,
more
yes.
colors, yes.
And early this month, the European Parliament Agriculture's Committee adopted its position on newly proposed rules for European geographical indications to protect the quality agriculture practice. So could you comment about these rules? Why now? Why could be expected as an effect of this legislative initiative commenced by the European Commission?
Mhm. Well, yes, there is an interesting development now in the legislative process in European Union, which concerns geographical indications, and those are intellectual property rights that identify products which have certain qualities, characteristics, or maybe reputation, which is connected to natural or human factors, maybe even the place of origin. And that's why we want to connect this product with a specific place. And for this purpose, we issue these geographical indications. And they have been in protections in EU since 1970s, because, you know, German European states cannot trade with their fine food and so on. I'm sure that's the same in every country, but we wanted to make it the law so that nobody takes it away. And there are almost 3,500 such geographical indications on the EU level, registered at the EU level as we speak. And the value is estimated to be 74.8 billion euros. And that's quite something as well. And what the legislators now want to do is introduce some elements of modernization in the system. And first of all, it relates to online abusive use of domain names. That was one of the problems, because it was seen an unfair competition where you have an online domain name, internet domain name, which has the same letters or words as the geographical indication. And it was difficult to fight it. Now, with this new legislation, if it's adopted in the end, it's only in the process of adoption, there should be possible to automatically close this domain name or assign it to the producer of the product in case. Some other elements of change would relate to a simpler registration process, because 6 months is quite a long time for doing this process, so they are trying to make it shorter. And also they are trying to have consumers more aware of the sustainable elements in those products. Sustainability is now the buzzword, I suppose, everywhere. But what the European Union legislator wants to do is put this into law so that the consumer gets a report on the sustainability elements of such products, so that they would be more likely to use them or appreciate them, and so on. One more thing which seems to be important to mention is that it would be possible now, it wasn't before, to also mention a geographical indication in the product which is processed, but in its processing, this geographical indication product was used. So it's not in itself, on its own, the product, but some other product which encompasses it, contains it. It will be possible to mention in the labeling, it contains elements of geographical indication, or product protected by geographical indication. So I think they want to reach to more people by doing this, and encourage also more industrial use of those products, I suppose. I'm not sure this is good, because in my opinion, the last thing, in my opinion, the geographical indication is as good as long as it's not really industrialized. Those products, more industrialized they become, less of the original quality they maintain. So that's unfortunately the case. So we'll see.
Okay, also thank you so much, Silvia and Ivana, very informative and helpful presentations. And so now for the final part and to end our event, I would call Martin Michaels, who is the chair of the IP, Genetic, Traditional Knowledge and Traditional Culture Expressions of AIPPI.
Thank you, Ana Claudia. Thank you, Silvana and Ivana. It was a wonderful presentation. I'm convinced that we are very lucky to have you as these speakers. And also, I want to especially appreciate Silvia, her flexibility, because she spoke about this silkworm, the rebirth of the silk industry the Horizon Project Arachne that's supposed to be in this webinar. But she was so kind with Professor Capellosi, and we will see in the second section of this series, because now we conclude the genetic resources first part of the series. We will now continue with the second part about the IP, the intersection of IP and cultural heritage and traditional cultural expressions. Also, before I explain this second part, I want also to appreciate Cinzia Elsa from IPPI, has a wonderful job, as well as from Giselle, member of the executive committee of ACIPI, and Daniela, the interpreter that we normally know, we don't see them, but she has made a great job. Why is it so important to point out that we are coming in the second part of this series? Because although we're having spoken about genetic resources, we are under the umbrella of traditional knowledge, and now will be linked with cultural heritage. And now in this second part, we have a link with genetic resources, and we will hear about the legal concept of the TCEs that seems to be already in the international negotiations that we are underway for the protection of the TCEs at WIPO. But at the same time, with the UNESCO Convention for the Safeguarding of the Immaterial Cultural Heritage is already celebrating the 20th anniversary. So we will see how is the intersection and tension with IP, and also cases, examples, such as, for instance, a case study of France about the key differences between the protection of TCEs and safeguarding will be important. And also this case of the silk art and cultural heritage will be an interesting cases. Also, we have good experts from the Minister of Culture of France, from UNESCO, as well as from WIPO. So I invite all of you to continue with this series because we will be interesting. And this will be a continuation in part for those patent experts for the Congress in Istanbul. I don't know, we can see the other slide, Cinzia. We want to invite you to attend for ACIPI this coming event in Quito from the 4th to 6th of June. Will be a very interesting agenda, and also to come to the APPI Congress in Istanbul, in which will be a very well organized, and we'll have a panel as well as roundtable APPI coffee about these issues of genetic resources and cultural expressions. So we invite everybody to attend it, the next webinars, as well as to attend the ACIPI meeting, as well as the Congress. Thank you all, and thank you, Cinzia, and all the support, Giselle, and this wonderful team that we were working on. Thank you all.